If it's happening, it's here. Victoria's News Authority, CFAX 1070. Now, the Ian Jessup Show.
The BC government came up against another roadblock last Friday in its effort to break ground on the $9 billion Site C hydro project in northeastern BC. Here to tell us what happens, Damien Gillis, documentary filmmaker and co-founder of the website The Common Sense Canadian. Damien, how are you?
Good, thanks, Ian. How about yourself?
Great. Now take us through what happened last Friday.
Well, it was actually the Crown, the federal government, that, with the support of the BC government, that was challenging essentially the guts of an application for judicial review led by Treaty 8 First Nations from Northeast BC into the way that the environmental certificate for Site C Dam was issued, and that was both by the province and the Crown. That happened last year, and they were very concerned about the way that went down, and particularly around their treaty rights, and felt that, and this treaty goes back to 1899, Treaty 8, which covers a large portion of northeast BC and northern Alberta. And what it did is it gave the Crown at the time the ability to settle and do development on this land, but it also guaranteed these First Nations the right to continue practicing their traditions on the land, including trapping, hunting, and fishing, unimpeded by that development. So it's always been about achieving a fair balance between the two. And flash forward over 100 years later, and they really feel, I think, with real justification, that with all the waves of development that have happened up there, including two previous dams, now with this third dam on the table that would flood half of the remaining section of the Peace River in British Columbia, and really affect what's left of that land for them to practice those traditions on, that they were not, those rights weren't taken into account by the government in issuing those certificates. What the Crown was trying to do essentially was strike key passages out of this judicial review that really went to the guts of that question of infringement of their rights, and they were unsuccessful in doing so. The judge essentially said, look, this deserves to be raised in front of a proper hearing in front of that judicial review, which is scheduled for July, and I'm not going to step in here and essentially gut this motion at this moment.
So let me see if I've got this straight. This Treaty 8, which was signed in 1899, allows the Aboriginals to practice their traditional rights on that land, but it also gives governments the opportunity to have economic development on the land. So it's a balance between the two. Now the First Nations there are saying, hey, we've given a lot in the past. Now we want this to stop with respect to Site C. Do I have that right?
Yeah, essentially, that's the case. And this was a treaty of peace and friendship, and it was designed essentially to provide opportunities for both parties, but they feel like this balance has shifted way in the other direction. There is a larger case that's being brought by another Treaty 8 nation called the Blueberry River First Nation, which really it's very dangerous to the government's and development plans, including shale gas and LNG, which would really impact the same region, and it is based on the fundamental breaking of this treaty promise. This particular case is a bit more procedural and technical, and what it is doing is zoning in on the way that the joint review panel hearings went forward around Site C, the way that First Nations and these concerns were ignored throughout that process, and then subsequently the government's refusal, and this was actually something new that came out of the hearing on Friday, is that they didn't even realize, the plaintiffs, that the government had completely ignored this issue of rights infringement in their own internal deliberations. They set up the review panel under the Harper government and changes that were made to environmental assessments a few years ago. Review panels like this don't actually have the final say on projects, and that's the case whether it's a pipeline or a dam. But what they do is they make a list of strong recommendations, and they pass those along to government. And the government's very much tied the hands of the panel in this case and told them that they could not review the question of whether the First Nations rights were being infringed here. What they were able to find and did find is that there would be significant impacts on that territory and, on the First Nations by extension, but they weren't able to go that extra step further and say, hey, this is actually going to infringe their rights, which brings in this whole treaty question, and it's a much more loaded legal concept. The government essentially designed the process to exclude that, but they had promised the First Nations that after receiving the panel's report, they would then relook at all the evidence that was presented in the review, and they would consider these issues. And what we learned on Friday is that they chose in the end to completely avoid any of that. And that seemed to be something that the judge reacted to. And he said, look, it's time for them to have a fair hearing over this particular question. And what the Crown was essentially arguing is that a judicial review, which is not a full trial, is not the place to hear these kinds of treaty and rights infringement issues. The judge disagreed, and he said this is going to go forward, and I'm not going to strike anything here. Plus, he ordered them to pay costs to the First Nations. So it's a pretty strong ruling by the presiding. It's actually called a prothonotary, similar to a judge in this case.
Yeah, what does that mean? I'd never heard that term.
The first time I ever heard of it. It's actually a protho-notary, like a special kind of notary who is empowered in cases like this, which is basically a review of a motion to strike. It basically acts very much the same as a judge. He sat there, he listened to the case, and he issued a ruling. So he was the presiding authority over the hearing. Protho-notary Lafreniere. Lafreniere is his last name, yeah. So instead of Justice Lafreniere,
okay.
his title is the prothonotary Lafreniere. That was the first time I ever heard that one either. But evidently he's a very experienced fellow. He's been doing this for several decades, and so highly respected. And he listened to both sides of this story here, and on the one side was both the federal government and the province presenting together, and they're essentially saying that they presented a body of jurisprudence that said this is not the place to hear this argument, and the prothonotary disagreed.
So this goes to judicial review July 8th, you said?
I believe that
sometime in July.
Sometime in July 8th, or maybe it's the 15th. Yeah.
Yeah, but, and where does it go from there?
Well, that will really depend on that particular what comes out of the hearing. I could see it. I'm clearly not a lawyer. I'm just observing this as an outsider, somebody who's done a fair amount of research on it. But I think there are a few possible ways that this could go. First of all, the fact that they had already submitted an application to speed up this hearing, and that was turned down before. So the governments are very concerned with wanting to get shovels in the ground on Site C as early as possible, and they've been saying summertime. And clearly with pending litigation like this hanging over the project, it would be really a bold move for them to go ahead and start construction under these circumstances, and they know that, and that's why they've wanted to sweep this stuff aside as quickly as possible. But one thing that First Nations cases around land rights are not known for is speed through the courts.
Yeah.
The Chilcotin case took 25 years to hear. So what could come out of this is a number of things. I suppose one thing is that the judicial review could essentially turn the First Nations down. It could also it could sort of concur with some of the concerns that were brought up here and say, I'm not the person to rule on this particular issue, which is a constitutional matter and deserves a full and proper hearing on its own. And in doing so, he could refer it to another court or another judge, and that could potentially hold back the hearing and the project for some time. Another thing that could happen is out of this, the nation could pursue, as was suggested during this hearing on Friday, they could also pursue an injunction, an interlocutory injunction against the project. This has happened before in BC. I think the last time, or one of the more prominent times, it doesn't happen very often, was Mears Island over logging issues, and that still hasn't been decided. So that was back in 1985. 30 years later, that logging is still on hold because there's this larger constitutional First Nations case that has to be sort of decided on before you can go ahead with development. So it's hard to say what will happen at this point. We're in some interesting kind of new ground, as the Crown argued here. Like, this isn't a common practice to put this kind of argument before judicial review. So we're in kind of some new territory here. But ultimately, I think it's got to be making these guys a bit nervous in wanting to go ahead and push this project through before they get tripped up in too many other ways. Yeah,
a listener who knew you were coming on the program today to talk about BC Hydro said, please ask your guest today how BC Hydro and BC Liberals are able to proceed prior to court appeals being heard and ruled on. Is BC Hydro so powerful they simply ignore judicial procedure? Thanks. And that was David sent that.
Well, that is a very apt question, and I think in some ways it's a bit of a rhetorical question. I agree with the spirit of it. That remains to be seen. I think that they were very much hoping that they would have to find that out, but you have essentially 7 cases here. There are also Treaty 8 Alberta on the other side. The river crosses the border, and there's provincial and federal cases being brought there. There's also the Landowners Association. They've raised $200,000 for their case, and these are farmers up and down the valley who would be affected by this project. They had an initial hearing on April 20th. That's yet to be ruled on. They have also another hearing coming up. And then there's this Blueberry River case, which is not specifically about Site C, but certainly encompasses Site C and LNG and gas development and anything else that's going to go on in that territory, because it goes to the core. This is essentially potentially another Chilcotin case, but slightly different in that the Chilcotin are talking about we're talking about asserted rights, and the courts eventually agreed and confirmed those rights at the Supreme Court that they have rights to that land, but they were never ceded or given away in a treaty type deal the way that the situation we're talking about here. In some sense, this is an even stronger case because there's no dispute about the rights. They're there on paper. There is a treaty in place. There's lots of documentation of the negotiators on behalf of Queen Victoria, the promises that they made, and the spirit of that agreement with the First Nations. So essentially going back to this deal and saying, hey, look, this has been pretty badly broken at this point, and we need to blow the whistle here on any further development before we sort these things out. So between all these different cases, it would be really shocking and I think disrespectful to both the courts and First Nations and the landowners and all the people involved in this case if they were so hell-bent on getting shovels in the ground that they just rolled over all of that and started construction. And I think if they were to go there, it would probably open the door to a strong case for an injunction from one of these parties.
Damien, here's my guess. There's probably a 6-year-old boy or girl in grade 1 today who will be fighting this case 40 years from now.
I wouldn't doubt it.
Yeah. Damien Gillis is our guest. He's a documentary filmmaker, co-founder of the Common Sense Canadian website. We'll take a break and we'll come right back.
CFAX 1070, winner of the 2015 Edward R. Murrow Award for Investigative Journalism. Victoria's breaking news and talk that matters. CFAX 1070. Informative talk. Now, the Ian Jessup Show.
Damien Gillis is our guest. He's a documentary filmmaker and co-founder of the Common Sense Canadian website. Damien, I've talked to the lawyer representing the residents in the Peace River area who will be impacted by this Site C dam. And the thing that struck me is that this is some of the best farmland in British Columbia with the capacity to feed 1 million people.
Yeah.
And now we're proposing to flood it.
Yeah, a little personal anecdote on this, Ian. My family settled in the Peace Valley over 100 years ago, and we had a beautiful ranch called Gold Bar at 20 Mile, which I never got to experience because it was flooded in 1968 for the first big dam up there. But I know from the accounts of my own family and the pictures in the Hudson's Hope Museum and from spending a lot of time in that valley. I didn't grow up there myself. It had a profound effect on my family and Many of my uncles work in the oil and gas industry today, and I probably would have been a farmer myself if it wasn't for some of these big government policies in the past. But I've kept in touch with the area and spent a lot of time up there documenting it through this Site C proposal. And it is some terrific farmland, and it's really surprising to a lot of people to learn that this is actually probably outside of the Fraser Valley the best farmland that we have in BC. And it hasn't really been developed a lot in the last several decades because this project has been on the table for over 30 years now, and Hydro has bought up a lot of that land, and they're just sitting on it under what they call the flood reserve. Also, it's hard to go to the bank and get a loan to develop your farming practice when the bank looks at it and says, well, this is going to be flooded in 5 years, so we're not going to give you the loan on that new tractor or whatever. So it's really, that's often cited, the lack of productivity of the land today is often cited as evidence that it's not that good a farmland. Well, that's an unfair argument, and several very respected agrologists presented evidence at the Joint Review Panel, including Wendy Holm, who's the former president of the BC Association of Agrologists, and they're looking at the soil science, and there's a tremendous amount of class 1 and 2 soils up there. It's high-grade alluvial soils. The valley runs largely from east to west, so it means that the sun is on it for a much longer period in the day. There's less shadows being cast by the mountains, etc. So you just have like a very unique climatic conditions and soils there that enable for longer growing seasons and much more productivity than places outside of the valley.
Yeah, they can grow watermelon there, can't they?
You should have seen and tasted the watermelon that the mayor and some of the farmers brought down when they now were talking about their case last year, and they brought it with them, and honey and all sorts of things. These beautiful golden yellow watermelons like I've never seen before, and amazing tasting. And there's all sorts of stuff, and I know that my family grew all manner of things that you would never even imagine, like avocados and things that you wouldn't even associate with the north. The reason this is really a big issue right now is that we import far more than half of the food we consume in BC, and our main provider of that is California. And as you know, and your listeners know, they're under severe drought conditions. Yeah. And Van City did a report just this last year predicting a 30 to 40% increase in produce prices at BC supermarkets because of that. So this is going to hit us in the pocketbook. But it's also a dangerous position to put ourselves in an era of climate change and increasing degradation of farmland down in the south, where there's so much pressure from other forms of development, residential and industrial and ports and all these other things, that they're not making any new farmland like this. So what we have up there is this great land bank that has been, preserved, and even though it hasn't been cultivated, it's there, and the potential is there. And we're talking about flooding this out at a cost of, let's call it what it is, well over $10 billion to taxpayers for power that really isn't even for us. I mean, the arguments that have been given have been for powering the LNG industry or for freeing up extra power to export to California, which would be at a considerable loss to taxpayers based on the power markets. In even the Joint Review Panel, in its hearings, their report, they acknowledge that the need for this dam has not been demonstrated, and even the economics are very shaky, and they haven't done the fundamental groundwork on it. So there's all these questions that are being raised. We're talking about trading food security and farmland that we do need for energy that we don't at a tremendous cost to taxpayers.
Damien, it's always a pleasure to talk to you. I appreciate your time. Thank you very much.
My pleasure, Ian. Thank you.
Thank you. That's Damien Gillis, documentary filmmaker and co-founder of the Common Sense Canadian.